My name is Wanda Davila. I'm the owner of El Patio Pop-Up Shop and vice president of the O4WBA Business Association. And today with us, we have Lee Morin of Morin Legal. Thank you, Lee, for joining us.
Thank you for having me again.
Of course. So what are we going to talk about today?
Today we continue our discussion on intellectual property and other important matters for small business owners, and we broaden the scope a little bit to include matters related to employment and financial reporting compliance, as well as revised definitions of how to define your contractors, and also rules that are banning certain provisions in employment contracts, which are also currently being challenged. So we'll get to all of those details in an organized fashion.
Let's try our best.
We'll do our best.
So we have a few topics to get through. Let's start with the FTC ban on non-competes.
Right. So the Federal Trade Commission, essentially, like all of the various administrative agencies we're going to be talking about today, provides rules and regulations, and they're essentially charged with making rules that ban unfair competition. And so what does that mean? So they've essentially decided, after some rulemaking procedures that are typical of administrative agencies, that non-competes are unfair competition. And really what that is to me, in the broadest scope, this rule, as well as the revised definition by the Department of Labor, is really leaning in favor of workers right now, which is very similar to like 100 years ago when you had labor unions coming up and getting strong. And so now we see this rule essentially banning non-competes in contracts for workers who are, day-to-day employees, may not have various responsibilities. So let's get to the exceptions and the exemptions. So essentially, I guess I'm assuming you understand what a non-compete is. So I'm curious,
I was just going to ask, yes.
I'm so glad I put this slide in here because I tend to roll on. But
yes.
Wanda, you tell me what you think a non-compete is.
It's when you leave your place of work. You've been working for company X, and once you leave, you're told that you can't work in a similar type company for a year or so. I mean, depending on whatever it's on that contract.
Right. So she named two elements there in her statement. She named a similar type of company and a durational requirement, right? Also, there's sometimes radius requirements as well, like within a particular distance, like 50 miles, 100 miles, or whatever. It depends on the reasonableness of the non-compete provision in the past, right? That's how they would be challenged in the past. Now, because they are banned and that rule goes into effect, and essentially the deadline for complying is in September. It's September 4th. So Labor Day is the more or less. Think of it as Labor Day. I actually haven't checked. Anyone know when Labor Day is this year? Is it early September? We'll come back and we'll check on that. But it's a good mnemonic, right?
Yes.
To remember that I better comply by September. And we'll get into what that means. But you're right. So it limits you in what you can do after you leave an employee. And so what the Federal Trade Commission basically said is it's not fair to limit workers who don't have certain access to information. And let's get into that next. So after now we know what a non-compete is, what is the information they are designed to protect? Well, confidential information, right? Company information that makes you competitive in the marketplace. That's why it's not fair to limit those workers who don't have access to that information from getting other jobs, when the whole point is to protect your information. So essentially, trade secrets are what we're talking about in a nutshell, although confidential information is much more than trade secrets. It can also be it can be broader, but just if you have to think of it as one thing, we can talk about it as trade secrets. So one workaround is, of course, focusing on protecting your trade secrets and how to do that when you're no longer allowed to have these non-compete provisions in your contracts starting this year. So what are the exceptions? Like I was saying, you're going to have some access to confidential information for that company in order for the non-compete provision to really stick. And so senior executives are an exception. And there's a whole lot more details that I can provide in a blog that we'll link you to when this podcast eventually presents, that goes into more detail. But without consulting a lawyer, this will just be information. This won't be advice. Always consult a lawyer if you're not sure if the exceptions apply to you or your workers or your employees. But essentially, a senior executive is in a policy-making position. They're a president, a CEO, or any other officer who has authority to make decisions. Essentially, what I like to call them in a single word is a manager. Legally, they are a manager. Right. They're the executive. And so those are the ones who are probably going to have like C-suite executives are going to have access to that information because they have to make decisions at a very high level. So they will have non-competes and it is very likely those will be adhesive. Those will adhere and be reasonable. Again, going back to the purpose and the spirit of the non-compete itself. A second exception is the sale of your business. So if you are the owner of a business being sold, then obviously you have an obligation not to go out and create another business competing with the business you just sold. I mean, there might be a necessary reason for that or a reasonable reason for that. But that's the other exception. So who doesn't even have to listen to the FTC? These are the exemptions, right? We just talked about the exceptions. Banks, savings and loans institutions are not affected. Federal credit unions, so like if you're an employee there, working there, this doesn't impact you at all. Common carriers like Federal Express, that type of thing. And this is where it gets really funky, so excuse me. Packers, swine contractors, live poultry dealers, stockyard owners, market agencies and dealers. So, agricultural businesses
Yes.
and so forth.
So these exceptions, what
and nonprofit institutions, they're just not under the authority of the Federal Trade Commission because the Federal Trade Commission basically has authority over for-profit institutions, and these are not for-profit institutions. So what's next? What do you have to do? And I just want to make sure I hit all the high points for you guys because really you're not interested in the drudgery. That's our job as attorneys. You got to let me do that. My job is to try and distill this into the most important details for you. So that's the goal of this podcast and that's the goal of our blog. So what are the requirements? Right now, if you are a business owner operating a business with non-compete provisions, first of all, you should just know if you even have contracts with any of your employees or workers. Like, are you even using contracts? Number one. Threshold moment there.
Yes. And you're a lawyer, you know about contracts and you can help people get that done.
Yeah. And I mean, if you haven't put anything in writing, there's ways to get it as quickly as possible, but essentially contracts. And then that'd be great because you don't have to worry about the notice requirements if you don't have anything in writing. The people who have to worry are the people who have the contracts in writing with the non-compete provisions that are in force and such. And they definitely have to provide notice to those workers, individual notice. Okay, mass emails are not okay. So this is why this is actually being challenged in litigation right now. I'm sure you can imagine there's companies with like 30,000 employees that all sign these standard non-competes that have to be individually notified, you guys, by September 4th. And they're all like,
yeah.
Like, I don't
That's
think
a lot
I
of
can
emails.
do it.
Yeah.
So people are vigorously challenging this. The authority, what's the legal word they like to use? Or they bury you, not the discomfort, but you get it'll come to me eventually. Sorry. And
we're 3 months away. So
yeah, but this has been out for a minute. We've had time to talk about this. So, but they give a sample notice, form here, which is very friendly of them to do. So you don't have to go and hire, a lawyer, although generally these companies have general counsels or some type of attorney serving as their general counsel on the outside. But you have a sample notice. And then in addition to reviewing the agreements that you do have to ensure that you've attended to all the ones with non-compete provisions, just look at your agreements, period, to see if you need anything to protect your trade secrets, right? Because again, the elimination of the non-compete provision opens up a door for trade secrets. And so we need to protect those. So if you haven't already thought of how to do that, this is the time to do that now. And so that is where you really do have to talk to a lawyer about getting like non-disclosure agreements or some type of trade secret protection in your employment contract, some kind of, confidentiality clauses are really popular, something to attend to that. And then, last but not least, if you're a small business with, 50 or fewer employees, I guess, and you have some C-level executives, maybe consider which of those executives need to have non-competes, which ones need to have them, And so this is a great time for, get a quick call or a quick consultation with a business attorney and say, hey, I have a company of 50 or fewer employees, maybe 100 or fewer max. I mean, you're looking at small businesses, closely held companies, partnerships, even companies of 10 or fewer employees might even have this applied to them. So they really all need to consider what they're doing with their contracts, what they're doing with their labor, and whether or not they're protecting their confidential information. That's it.
Yeah, I mean, that's money. If you don't protect your information, then somebody else is going to be making money with your information.
Right, which is a great segue. But before we seg into trade secrets, is there anything else we should talk about before we leave the FTC ban on non-competes, Wanda?
I think for the layperson like me, that was enough information.
Scary enough. Let's get on to the next terrifying
my head was spinning
topic.
just a tiny bit. But basically, in a nutshell, is there are more protections coming up for the layperson. The person who's not necessarily up there making the decisions, and it's coming up in September.
Yeah, I mean, as a worker, you're going to have more mobility. And I forgot to mention the legislation, which is actually a really nice way of capturing what the worker gets out of all this. The legislation, I just had it in front of me, that is currently in front of Congress is called the Workforce Mobility Act of 2023. So this is about making more mobile citizens, to ban employee non-competes, to allow workers who don't have access to confidential information to travel between jobs without being restricted unfairly, right? So another piece of legislation is the Freedom to Compete Act, to ban non-competes for workers who are not exempt under the Federal Labor Standards Act, which protects non-exempt employees. There's also, believe it or not, vaccine mandates and eliminate non-competes act to avoid non-competes for employees fired for not complying with their employer's COVID-19 vaccine mandates. And last but not least, there's a piece of legislation affecting physicians called the Conrad State 30 and Physician Access Reauthorization Act, which speaks on immigration issues for physicians in underserved communities, including a ban on non-competes for those physicians. So there's a lot of really varied legislation. And why do we have 4 pieces of legislation to attend to the same topic? I mean, it's just because, people get the wording onto the legislation where and when they can, and you get sponsors where and when you can, and things come to the table when they can. And if a piece of legislation is drafted, you don't want to hold up another piece that's already on its way. You might create a new, it might attach to a new bill. I used to be a legislative aide. It's not a fun job in the sense of, it's a lot of paperwork and a lot of minutia. And so when I give you the legislation, the one takeaway I want you to remember of all the ones that I just mentioned to you is the Workforce Mobility Act. That's the one you're going to pay attention to, because that's the one that's really probably going to affect you the most.
I got a question real quick.
Yeah, Pete has a question.
When I was back, I remember starting years and years ago, we were in radio. And you would jump around from radio station to radio station in the same market. And then all of a sudden, non-competes popped up. And they tried to lock us in for a 3-month, and we're salespeople. We weren't managers of note. And they would try to lock us in. And it was I always felt, I don't even know if this is even legal anymore. But as a workforce person at the time, right, we spoke manager, it was so, you had to really plan yourself, because it wasn't like you were making so much money, or at the time you had so much reserve built up. But as a young person starting out, you really had to, it hurt.
Yeah.
I remember that going wow, I can't make money for 3 months. We call it sitting out. And we used to have to pay our rents for 3 months, and that was because we were just moving to another.
Under this definition, you would not meet the senior executive for a non-compete to apply. And you certainly didn't sell your company. So let's just say you're not a policymaker in the radio station. You wouldn't be a manager per se, right? Making
no.
managerial.
You're just
I know you're
regular-
just a talent, right? You're just
Yes.
talent. You're hired talent.
Yes.
And then on top of it, you're obviously not an officer of the station. And then last but not least, your compensation. I think they had an argument that anyone who makes over 154,000, some ridiculous, very accurate number,
Yeah.
would qualify as a senior executive, but they're not paying you over 150
Then,
grand.
No, I mean this was many years ago.
Yeah,
Right, just 20 some odd years ago. 20,
Yeah,
but still, I remember.
adjusted for inflation.
But I remember back then how just horribly.
Damn, that sounds really unfair, Pete. I think that was an illegal non-compete clause.
But because many times
Damn.
talent, we don't know how to advocate for ourselves.
No, that's true, and that's why you
know.
need an entertainment lawyer.
Exactly.
You
right?
know, like the ones you find it more legal to help you through some nightmare like that. We've actually fielded employees through nightmare situations where they've been sprung with invention disclosure agreements partway through their employ, which are now illegal for the non-compete. You cannot have a post-employee non-compete now. It'll have to be before.
And they would do that then?
Yes, they did. So those are not allowed now, according to the Federal Trade Commission. Wow. So there's a lot of changes.
That's
This is very
good.
informative.
I'm telling
Yes.
you.
So this Labor Day, there's lots to celebrate.
This September. Don't go to
Yeah.
Dragon Con. Talk to your lawyer, certainly.
Yeah.
So we were talking about what information are these non-competes really designed to protect, and we were talking about trade secrets,
Yes.
and that is actually, hopefully we're all on time for topics. Our moderators will tell us, but we're about to dive into topic number 2. What are trade secrets? And let's tell you there are 3 elements because, as a lawyer, we like to break things down into bullet points and numbers, and that's just how my brain works. So number 1, trade secrets are confidential information. What does that mean? That means that information has an economic value because it is a secret, because it is not known to others, because it is a secret. So important to remember that. And then lastly, its owner, that is the business owner ideally, has made a reasonable effort to keep it a secret. That means you've actually gone out and thought, who has access to my customer lists and who has access to my hard drives? And am I making an effort to protect my information from my employees, interns, contractors, volunteers, anybody who has access to my office, basically, or my computer, my laptop, my desk, anything, my devices? Am I making reasonable efforts to protect? Do I have a firewall? I mean, stuff like that. It's just such basic stuff that really seems front loaded a lot with computers anyway these days. So as long as you're using all the, maybe getting some extra software for virus scanning and stuff probably is helpful, especially since cybercrime seems to be so rampant now.
I was going to say, there have been stories
Yeah.
on the news about
the worst.
just other countries
And that is
stealing
exactly
information.
what they're stealing. They're stealing your trade secrets and they're
Yeah.
holding them hostage. And it's so bad. And in some cases, even worse. They're stealing even worse. So certainly get the basic stuff and protect. Update your website. Update your. We get attacks all the time on our website, and I have licensed software that I get the professional grade protection. And I still back up every day, stuff like that. You back up constantly, routine backups, there's literally a whole class we could give
About that, yeah.
on how to protect your trade secrets. But for now, we just want you to know what they are. They're secret, they're not known, and they have an economic value to your company because they are not known. So recipes, the Coca-Cola formula is one of the most famous trade secrets known to man.
Yeah.
But your recipes are trade secrets. Your special sauce is literally special because it's a secret. So your employees who are going to make that for you are going to have to sign some type of documentation in order to protect that trade secret, which you can then take to a court and enforce in the event they somehow start a competing business where, oh, wow, that's really familiar tasting sauce you got there, sir. So this stuff happens a lot so often and people just don't know how to protect themselves. So you go to a small business lawyer because trade secret theft is not only a civil crime, a civil cause of action. It is a crime as well. So there are civil and criminal penalties for theft of trade secrets, theft by conversion. Like I take your clients, I start using them as my own, and I exclude you. Like if you have a Google Drive with your partner and suddenly, boop, I don't have access to all my stuff. And your partner's going off and they're running the company, they're running the business, they're answering your phone calls. This happens all the time.
Wow.
You would not believe, y'all. You would not believe. It's so heartbreaking. And these are like best friends that grew up and, and they just don't have paper. They don't have paper between them. They don't have maybe a business even organized. There may be a general partnership where they never even registered as an entity and they're just doing business as like party promoters, all people who handle this cash money, in this entertainment world or live performance, whatever you're doing as an independent freelancer, a lot of the time you don't realize that your value comes from your network and your network is a trade secret. It is a trade secret. Who you know is a trade secret. Your phone is that information in your phone are trade secrets. So someone steals your phone, that is theft by conversion. Boom. That's a crime.
What about
That's a crime.
when you have a product that is internationally recognized and somebody from outside the US steals your trade secrets?
Sure. That's like espionage, more or less. And it does happen. Also a crime, obviously. So typically you need to protect your trade secrets from thieves, like we're saying right now. People who want to take your trade secrets to make money for personal gain, maybe sell them or use them. Second type of people trying to take your trade secret confidential information are your competitors. And that's the espionage angle, right? They want your trade secrets or your information, your vendors, your suppliers, et cetera, to outdo or compete with you. And that's also not allowed. Go figure. And then last but not least, you have to worry about your adversaries, people who just want to see you burn for whatever reason. There are people who are haters out there. So how do you protect yourself as a business owner, really? What do I need to do now that I know that my trade secrets are basically everything except my copyrights, my patents, and my trademarks and my trade dress? So client lists, supply list, vendor list, all your lists, all your financial information, anything, financial projections, sales, market research, anything about your industry, your business that makes you competitive that is not public as a trade secret. So first and foremost, you can just go ahead and register, your trademarks and copyrights and your patents. If you have those, get those handled. But then everything else is really identified with an attorney and then protected under contracts. So non-disclosure agreements and confidentiality agreements. And that's pretty straightforward. And we'll send you a link to our blog so you can read more in detail about how to do this, how to identify the risks, how to train employees and your vendors as you might need to, and then how to work with a lawyer to get resolution on your trade secrets.
So it's two parts. One, it's protecting it, not only with the firewall, but actually identifying and protecting it. But then if something happens, work with a lawyer to get that resolved.
Yeah, so I think you should work with a lawyer to identify first what the trade secrets are if you don't know what they are, and a lot of people don't. They are it's such a amorphous, androgynous idea to them, an abstract concept, because a copyright is something like a song or a movie. Like I can know what a dance routine. A photograph is there's a copyright in it, although copyright can be damn elusive too. I should not say that at all. Copyright is really hard. But trademarks like brands, like my slogan, my logo, that's patents like inventions, but trade secrets literally everything else. But it might not be everything, Wanda. So that's where it gets confusing. So we have these clauses that cover everything, these trade secrets clauses, and we just plug them in to either an employment agreement in a confidentiality section of the agreement that protects the trade secrets there, or if you're doing business with somebody like a joint venture, like a partnership, and you're not sure things are going to work out good, but you kind of want to see how things are going, and you got to disclose some private stuff in order to figure it out. That's a non-disclosure agreement. We do those for flat fees for $200 a piece. They're so straightforward, front and back, mutual terms, and they're just the easiest, lowest threshold protection you can get if you're going to talk to somebody about your private business. I can't recommend enough to hire a lawyer to give you that document. Just a basic document to have in your treasure chest, non-disclosure, a mutual non-disclosure agreement, and a confidentiality clause that you can plug into your employment contracts. For your trade secrets. That's it.
My head is spinning.
Okay.
Just a little bit.
We're only halfway through, by the way.
So let's talk Department of Labor.
So we've been talking about this rule for a little over a year at my practice, and I think we might have done some videos, or we definitely did a blog on it. And so following up on that, the final rule was announced in January this year and became effective on March 11th, 2024, and essentially really puts into final text how to classify an independent contractor from an employee. And this is important because small businesses have in the past perhaps been able to skirt certain costs because they were able to use independent contractors who really functionally were more like employees because they were under their supervision. They might not have had decision-making authority over how to do their work. They might have received essentially a salary, a static payment instead of a payment that they might change and expand because they might be an owner and have a percentage of an ownership. You see, so they thought, this doesn't seem right. We should certainly close that gap because workers deserve benefits. And if you're going to be working primarily at this entity, under this direction and supervision and learning skills on the job and getting a routine paycheck, then, you probably should get benefits too.
So that's the definition basically of a, the difference between a contractor and an employee.
We're going to get into those details. Yes,
Okay.
yes. There's six stipulations that distinguish a worker from an employee according to the Department of Labor's revised definition. So here's the substance of the rule, and we'll get into each one on a very high level because if we didn't, we would be here all day. Number one, opportunity for profit or loss depending on the managerial skill. Number two, the investments by the worker and the potential employer. Number three, the degree of permanence in the work relationship. Number four, the nature and degree of control of the worker in the job aspects. And number five, the extent to which the work performed is an integral part of the employer's business. And number six, skill and initiative. This cannot be voluntarily waived, by the way. So your status, your work status, often you see in employment contracts, what is the relationship status of me to you? And it'll say stuff like, you're an independent contractor. You're not an employee. You're not entitled to benefits. You got to take out your own taxes. Does this sound familiar?
Oh,
Maybe
yes.
to many of us who
Yes.
have seen these contracts. So you cannot waive this. If you meet this test. And that's why businesses must understand when this test applies so they don't get caught with this kind of stuff, because this is now enforceable. So, and no one factor is going to determine. They're what we call a cumulative test. So that just makes it so much more confusing for everybody, of course.
But I mean, basically, it's like the difference between having somebody on staff that cleans every day versus just hiring a once-off
We'll get
cleaning
into that.
service.
We'll get into that. I think in the nutshell, the 6 factors that we just mentioned, when they're weighed together, the idea is to develop a decision on whether their economic reality is one of dependence or independence. And that's essentially what we're looking at. Are you economically dependent or independent? And so essentially the opportunity for profit or loss, which is the first factor, the way I boil this down into the nutshell is if the worker is a profit share partner, like a shareholder, they're more likely a partner. If they're not, able to increase or if their income doesn't increase or decrease based on the performance of the company, and we're not talking about these big corporations where you might have a 401k where you get like a percentage or something. We're talking about common stock shareholder, someone who has the decision-making abilities, not some A, Premier, B, C stock, or, whatever letter stock you might be, that doesn't have any authority. This is something for, depending on the managerial skill. Also managers, you're looking at somebody with decision-making power. Investments by the worker and the employee. Are you investing capital into this business or not? or for example, are you investing into your personal 401k? That might be an employee. Whereas if I'm investing capital into the company, that might like a partner loan, like a company loan, like I'm making a personal loan to the company, to meet some type of obligation, which I would have priority over other creditors, as the company owner. That's more like a less an employee, more of a contractor, like a joint venturer. A lot of the time we have these independent entities coming together under joint ventures, right? And especially the small companies, like partnerships, and so they're not going to be each other's employee. You see what I'm saying? They're more likely going to be seen as a contractor, each one equal. An equal contractor. And so what is a joint venture? But essentially, it's just a marriage of two entities or more entities. But for lack of a better term, in the Department of Labor's way of looking at things, two independent contractors coming together, right? And that's why these are important to understand the distinction, because you're going to want to make sure that the relationship of the parties clause is clear, and that you're responsible for providing benefits and payments to unemployment and so forth if these employees are in fact employees. And so what Wanda was saying earlier about, what were you saying? Give me some examples of what you think like a worker would be in an industry that we all know.
So
Like a restaurant.
yeah. So let's say I was thinking like an office space, for example. Like one thing is when you hire a cleaning company, but you're not paying them. You're hiring them. So yeah, I thought it was clear in my head.
I would say that would be an independent contractor more likely, because they're coming in. So that pairs nicely into the next factor, which is the degree of permanence. So they're only there to do their job and leave and go do a job at another building, right? That cleaning company is not there to be there all day long working for that building. If they were, they're probably going to be an employee. Right. But if they're just there to do their job and they're off to the next address at this next building, wherever, that's more likely going to be that's an impermanent relationship. That's a finite time that they're at that site. And so it's less likely. Also, they don't have any control. They're getting a paycheck. They're not dictating how the job is being done. They're being told how the job is being done. But they also have some leeway as to what cleaning products they choose. So in a sense, a worker would be subject to the budget of the company and the supplies of the company, whereas an independent contractor has their own budget. They have their own supplies.
I see.
They're only there for a certain period of time. So these are the nature and the degree of control over how I do my job, right? How do I do my job? And last but not least, what's the work I'm doing? Is it an integral part? Well, cleaning a building is not an integral part to the building functioning, really. It's an important part, sanitary reasons.
Yes.
But the building still is functional. It has electricity, it's open, whatever it's sort of a weird example, but the work, like a software engineer is one example that I like to use a lot, because engineers are brilliant. They have the patents of the company, usually are developed by them. Of course, they're owned by the company, of course, always. And their work might be integral. It might be a software company. The work of the engineer is integral to that company. Less likely that they're going to be an independent contractor, therefore. Do you see? Because what they do for a software company, a software engineer would be integral to the company. An independent contractor for that entity would be somebody like maybe a designer who would come in, or a campaign or a public relations person who would come in and help them prepare for a launch of a product or something.
Yes.
Like some PR person, some flashy person. Because let's be honest, engineers are pretty bland. No, I'm kidding. I say that with love, because I worked for so many of them for 8 years. As a patent secretary, a patent paralegal, and yeah. So skill and initiative, again, if you take the initiative, if you bring skills to the table, if you're hired for your skills, you're going to be more likely a contractor, somebody who's a specialist who comes in, does the job and goes. You take the initiative.
And then the length of time has something to do with that. Like you mentioned, coming in for a campaign versus
you have that special
work.
skill. Everybody wants your special sauce, so they hire you. When you come in, you do your show and you go. So that's the contractor. On contrast, the employee is seeking skills. They're seeking to acquire skills through the job, right? They didn't come to they might have some reading and writing skills, communication skills, but they're coming to get trained, and they take direction. They don't have. We all like to see worker initiative, but let's be honest, we really do like top-down management too. So we like it when they follow directions. So there you go, workers versus contractors. And that in a nutshell is how you tell the difference according to the Department of Labor. And if you're not sure, again, look at our blog. We'll send you the link and consult with an attorney if you have any questions, because what's really important is that you go ahead and comply since the law is effective as of now. So, Department of Labor has been known, there's all kinds of enforcement out there. You never know when you're going to have to report. So I think it's important to at least understand the rule and understand your risk level, because if you're knowingly operating your company with contractors, knowing that they are not technically contractors anymore, you're running a big, big risk and big, big penalties. So certainly seek a lawyer if you're confused. Don't waste time and don't wait, because again, the law is already effective.
So what happens, if you get caught not complying?
Think about this. Think of all the back taxes and payments for unemployment and benefits and things that your employees would be entitled to if they were to, say, hey, I'm an employee, I'm entitled to all of this, that you haven't been attending to since this rule has been effective. Essentially, that's what you're looking at. So workers are really on notice right now. You're on notice to understand as much as the business owners, really, because the workers have as much a right to know what they are, what category they fall into, don't they?
Yeah.
And what they're entitled to. And I think that's, again, this is legislation for the workers this year. You guys are really killing it.
Well, how about we move on to our last
Ayn Rand
topic?
would not be happy at all. She'd be very upset. She's rolling in her grave. All right.
So the last topic on our agenda
is financial crimes, because the juiciest subject must be saved for last.
This is what shows are made of. I love it. I love those about the financial crimes.
I tell you what, this is where it gets personal, because as the attorney, my information must be filed with any business that I register under this new law. So my birthday, my driver's license will be on file. So this is where it gets personal for me too. Okay,
wow.
So I looked at this and I thought, man, what are you going to do? In 2021, the Corporate Transparency Act was passed, and essentially they're trying to limit the chances for us to use corporate shells as fraudulent vehicles for financial transactions. Imagine that. I don't know where they got that idea. They are just dreaming if they think anyone would cheat the system. What kind of ridiculous people do they think we are?
So people just open accounts in the Cayman Islands just because of the views of the beach?
They'll open a company that owns a company that might have another company that may or may not have assets, that may or may not have the title to something. And then you may not be able to get in touch with that person, the authorized representative. So you may not ever be able to foreclose on certain things, property especially, if you can't get the title.
Wow.
So there's all kinds of things that people use this stuff to elude and evade various requirements, financial requirements, reporting requirements. So the Financial Crimes Enforcement Network is a subsidiary agency, if you will, through the Department of the Treasury. And they are charged with regulating this information and providing this information behind millions of firewalls, they say, of course, to the interest holders, the stakeholders like banks and other people who want to verify your information. And I actually have a whole list of everyone who's going to have access to this because, of course, I want to know who's going to have a copy of my passport.
This is not related to the Panama Papers.
I'm just an informed citizen. Who am I? Gee. But I want to know, because this is like all of your private information out there, you know, and when we just talked about cybercrime, this is obviously a government agency. And how many times have we heard of government agencies being owned by,
being hit on these like hijacks?
Like foreign entities or foreign organizations or who knows who. So what does this mean? Essentially, we have a reporting requirement. If you have taken advantage of the registering your business entity under the business statutes of the state of Georgia with the Secretary of State, which is the administrative agency that regulates business in the state of Georgia, then you are required. So that means if you have formed a corporation, an Inc., if you have formed an LLC, a limited liability company, if you have formed a limited partnership, any of these business entities that you form by filing online are required, no exceptions. And you cannot, and there's very few exceptions. I shouldn't say no, but if you were formed as an entity before 2024, your filing deadline, and this is important. We all have the deadlines. There's 3 sets of deadlines that are really important to remember. And for most of us, we've already had our companies. My company's been existing a while. Your company has existed a while. I'm sure Scutch has been in existence for a while in Georgia. So we're not new. We didn't just file this year, So our deadline is the 1st of January, 2025. Oh. So we have to get our reports in if we are filed as an LLC, like I just said, an Inc., et cetera. If you at all at the Secretary of State. Now, if you were a sole proprietorship and you filed a fictional trade name application at the Superior Court County Clerk's Office, then you do not have to register. Okay, so sole proprietors are exempt. Oh. And there's a whole bunch of other exempt organizations that I'll mention in a minute, and mostly banks and financial organizations, because I'm sure they're already regulated. But private entities, who are registered, and nonprofit organizations, I believe, are also exempt, but I'll get to that in a minute, because they're regulated so hard already under 501c3. Man, the IRS, for anyone who's ever had to do reporting for a 501c3, it's so onerous. Like, you would understand. I'm sure I understand why they're exempt, because there's already a system in place that thoroughly examines them every year. But for everybody else, us private small business owners, you organize your business this year, and this is where it gets interesting. You have 90 days in order to register. So if you formed your company, you have 90 days. If those 90 days is up, oh my gosh, you guys, the penalties are horrifying. I will get to those at the end of this talk.
Yeah, I'm like, where do I do this right now?
But if you formed your company in 2024, you bet I ran to the SOS and I looked at all the businesses I formed this year to make sure we were still within those 90 days. I'm like, whew. But 90 days this year, you guys, if you form your company this year, you have 90 days to register. It is very important, because the penalties are like $500 a day. $500 a day. Imprisonment up to 2 years, $10,000 fines. I'll get into the detail in a minute, but that's just to get your attention. Okay. And the other deadline, last but not least, is if you form in 2025 and after, you have 30 days to register. So it's even a shorter time. Wow. So this is really important. So how are they getting the word out? Well, business associations. Boom, Wanda.
You're welcome.
So thank God we have a year to get the word out. This is so important.
Why is this not on the news? Everywhere.
Because the election is on the news, Wanda. Right, come on. Priorities. So here's the best part. We're gonna put the link in the comment. in the blog for you. So there's a link. You literally click on the link. You file the form online. It's easy peasy. You get it done. Now, what's not easy is what information is required, right? So that's where you actually have to go and get the information from everyone and figure out who's a beneficial owner and what is a reporting company. I just told you what a reporting company is. It's going to be if you register at the Secretary of State's office, if you ever file an annual registration, you are a reporting company.
Yeah.
That's it. So what is a beneficial owner? It's one of two things. You either have substantial control over the company, or you have a 25% ownership interest in the company. It's one or the other. It can be either or. So, you'll go through your, small companies. This is pretty straightforward for you. You might have to go through your record books and your stock books to figure out who's the 25% owners or more of your business. But, that's, again, something you can do with an attorney and your CPA if you feel comfortable with that. I would recommend that. Businesses that make more than $5 million a year are exempt. I'm sure none of our small businesses, with the exception of maybe Slutty Vegan, in Old Fourth Ward and grossing more than $5 million a year. It's a joke. Sorry, had to make a dig at Slutty Vegan because they're on my street. And then only for those companies that were formed in 2024, right? So not us. Only for the companies in 2024 and forward. you have to also include a third piece of information. Totally annoying because it means I have to put my information down there. That's why it's totally annoying. But it's one more bell and whistle. And yes, you can have a lawyer do this for you. Absolutely. But you can also do this for yourself. Just FYI. But some people feel better having a lawyer go through all of these things, like Pete was saying earlier, a TAC list and checking off and making sure you're compliant for 2024.
Yeah.
We'll create a TAC list at the end of our blog, so you can do that for yourself with the links. So you can either DIY it or you can contact an attorney at our firm for a consultation and advice on how to approach it, especially if you have all those contracts. Maybe you need someone to take a look at them. And then I think that's it. So once you identify those bits of information, you report it online. You only have to file one time. There is no fee, and you will not be filing every year. That's the good news. The only reason you would update it is if you change information, right? If you change addresses, if you change a beneficial owner changes, so obviously changes require an update. So that's the compliance aspect you have to remember.
So we have homeworks, right? We have to get some things done so we don't get into trouble. For all those small business owners watching this video. And if they have any more questions, where can they reach you?
So we're going to have, again, hopefully in the YouTube channel, which is where this podcast will post in the comments section or the description. We'll have a link to our blog. We'll also have links to some of this information that I pulled off the internet. So, but I think the blog is really going to be the one-stop shop where you can go and just see the distilled part. As a documentarian, I like to always include my work, check my work, my bibliography. So I'll probably put in here also, the FAQ from the Department of Labor. So y'all have access to that. I think there was even a really cool infographic in my blog, and that's actually government property. So it's public domain. And then the FAQ on the beneficial owner information, which is exhaustive. If you really want to read about it, it's 48 pages long. We do free phone calls, 15-minute phone calls. If you're freaking out and you're not sure, what's up, you can call our phone number, 404-800-5568. I tried to make it a cool 800 number, but I just got a 404 number. What can I say? 404-800-5568. And you can ask for a discovery call and get a quick meeting with me, and also, an answer of, do I need to consult with you? I'll ask you, who are you first? Are we conflicted to represent you? And number two, how bad is it? And that's when you tell me everything that's bad.
I mean, it's not a therapy session, but
It kind of is. I mean, really, we are counselors technically.
Well, I want to thank you, Lee. This was amazing. A little bit overwhelming, but good to know. Very important to know. If you forgot, this is the Old Fourth Ward Business Association technical session. Trademarks. What was it?
Trade secrets.
Trade secrets and
non-compete bans.
Yeah, she knows what we were talking about.
Independent contractor classification and financial crimes.
And I'm Wanda Davila, owner of El Patio Pop-Up Shop and vice president of the Business Association. I hope to see you again next time. Take care.